Hello everyone, I'm Nazarat Fatima. Welcome to Live Law. The Karnataka High Court has dismissed a petition filed by a husband seeking to quash the complaint registered by his wife under Section 498A of the Indian Penal Code after he sent her a legal notice seeking amicable settlement for dissolution of marriage. Let's briefly go into the facts of the case. A woman had lodged a complaint under Sections 498A, 307 and 506 of the IPC and Sections 3 and 4 of the Dowry Prohibition Act 1961 against her husband and had alleged that there were several instances of torture, mental and physical, against her by her husband. She had also told the court that her husband tried to take away her life by strangling her and she had to take treatment for spinal cord injury. As per her, she had left the matrimonial house after alleged torture and her husband had sent her a legal notice seeking amicable settlement and resolution of the dispute between them for the purpose of dissolution of marriage. The husband contended in the petition that the complaint is a counterblast to his legal notice and the offences under Section 498A of the IPC are not made out. The matter was heard by a single bench of Justice M. Naga Prasanna. The court observed, and I quote, "There cannot be a declaration of law as is contended by the learned counsel for the petitioner that once the divorce notice is sent by the husband, the complaint registered by the wife thereafter loses its significance. If this contention is accepted, it would have a chilling effect on all the complaints. Therefore, this submission is noted only to be rejected as it is fundamentally flawed." The court went through the complaint and based on it was of the view that prima facie offences alleged are made out and they are to be investigated. It said, and I quote, "The statements recorded during investigation clearly indicate that those ingredients are prima facie met. Section 307 of the IPC is also alleged against the petitioner. The complaint clearly makes out ingredients of the offence under Section 307 of the IPC, which deals with attempt to murder. Strangulation and giving blows on the back is what is alleged in the complaint. If these ingredients are to be ignored and brushed aside merely because the complaint is registered immediately after receipt of the notice of divorce or amicable settlement for dissolution of marriage, it would lead to a disastrous effect." The court explained that in a given case, if the allegations of torture are made over a period of time, the husband issuing a notice for divorce simultaneously or immediately before the complaint will not result in the complaint making itself insignificant. The court said that it would require investigation. It would be altogether a different circumstance if the complaint does not even make out the ingredients of the alleged offence or does not lay down the necessary foundation for alleging the offences in a given case. Then the bench agreed that there are many cases where members of the family are unnecessarily dragged into the web of crime by the wife while registering the complaint invoking Section 498A of the Indian Penal Code. However, the allegations have to be considered on a case-to-case basis. It disagreed with the coordinate bench judgment, which held that FIR should be quashed on the sole ground that the crime is registered after receipt of a notice seeking dissolution of marriage. The bench said it defeats the very object of Section 498A of the IPC or even complaints made under Section 12 of the Protection of Women from Domestic Violence Act 2005. The court noted that Section 498A was brought in the Indian Penal Code with the objective to prevent torture to a woman by her husband or by the relatives of the husband. That's all about it for today. We hope you like our content. If you do, please like and share our videos. Also subscribe to our channel on YouTube and don't forget to press the bell icon for notifications. Thank you for watching.